In the matter of Anmol versus Union of India, Supreme Court allowed the appeal and set aside the judgment and order dated 23 September 2024 passed by a division bench of the High Court of Punjab and Haryana at Chandigarh, confirming the admission granted to appellant by virtue of order dated 12 December 2024 in Government Medical College Sirohi. The court also directed matter to be posted on 3 March 2025 to consider whether the National Medical Commission has formulated revised guidelines as directed in Omkar Ramchandra Gord and Om Rathod, and further directed that NMC shall file an affidavit explaining the current status before the said hearing date. In the judgment of 15/10/2024 in Omkar Ramchandra Group, a direction was given to National Medical Commission to issue revised regulations and guidelines in suppression of guidelines of 13 May 2019 with regard to admission of students with specified disabilities under RPwD Act with respect to MBBS course. The court had also directed NMC in pursuant of the communication of Ministry of Social Justice and Empowerment dated 25 January 2024. Pursuant to judgment in Omkar Ramchandra Gord, NMC assured this court during the course of hearing in Om Rathod that it will constitute a new committee of domain experts to comply with the judgments in Omkar Ramchandra Gord. Noting assurance of NMC, the court directed that the committee be so constituted will include persons with disability or one or more experts conversant with disability rights. Further direction was given that fresh guidelines would be put in place applying principles set out in these judgments. The court was of the view that the correct approach is not to bar a candidate at the threshold but grant the candidate choice after completing MBBS to decide whether he wishes to specialize in non-surgical or medical branch or continue as a general duty medical officer. As rightly set out by Dr. Satendra Singh, it will be unfair to presume incompetence at threshold without providing an opportunity to candidates and ensuring availability of accommodations and assistive products. A prescription such as both hands intact reeks of ableism and has no place in statutory regulation. In fact, it has effect of denuding the rights granted under the Constitution and RPwD Act and makes a mockery of the principle of reasonable accommodation. We have also held that such an insistence in a statutory regulation absolutely antithetical to the objectives of Article 41 and principles set out in the United Nations Convention and the rights granted under the RPwD Act. While we are conscious that courts are not expert bodies in the matters of medicine, as held in Om Rathod, courts have the jurisdiction to ensure the manner in which the board proceeds and functions are in compliance with the established principles of law. We will only add that it's just a question of jurisdiction of the court, but also a duty cast upon the court, since it's the courts which enforce the fundamental rights. The court concluded that we have no hesitation in concluding that the report of the five members of All India Institute of Medical Sciences cannot be the basis to deny the appellant's admission to the MBBS course.